All right, good morning, everybody, and welcome to this edition of the Interactive Dialogue. My name is Mike Droke, and I'm delighted to have you here. As those who have listened to our presentation before know, we have a system that requires you to both phone in from your phone and also log in on the web. And so if you have a neighbor sitting next to you that can't seem to hear what we're talking about, please nudge them and remind them to phone into the access code, which is listed here on our presentation materials. I'll highlight it again for those who are logging in on the web. I've been watching the states log in as we've come along here, and we've got quite a bit of coverage. We've got folks from Minnesota, California, Washington, New Mexico, Illinois, New York, really all across the country to talk here today about protecting your brands in the food, agriculture, and beverages industry. So I'm really excited to bring to you this new format that we've developed here at Dorsey. Most lawyers have webinars where they crash a whole bunch of different slides through the internet in a lecture-style format, and we thought it'd be fun to have a conversation about a topic where I play the role of a client, and then I bring in one of the experts from our firm, like Jeff Cadwell today, to talk about a particular issue. So that's what we'll be doing today, talking about protecting your brand in the food, agriculture, and beverages practice space. As you're listening in, if you have any questions, you'll notice a participant feedback chat pane on the left-hand side of the screen. And please, if you have any questions, just let us know in that chat field. I'll make sure either to ask the question or weave it in to the presentation as we're going along. You're welcome to ask them confidentially, so we won't identify who the person who requested it is. Just make sure and mention that. Otherwise, if I know you, I might call out your name and thank you for participating in the call and asking a question. So my name is Mike Droke. I've been practicing here at Dorsey for 20 of my 25 years of practice. I've been proud to represent the food, agribusiness, and cooperatives practice space for a long time. And in that context, among other things, I act as kind of the de facto general counsel for certain cooperatives and the like. And so when I do that, I have the privilege of working with great professionals around the firm, kind of as their client internally in a way. And one of those is Jeff Cadwell. So Jeff is a partner in our Minneapolis office, and he and I have worked together on a variety of different clients, in particular in the food and agribusiness space. Jeff, do you want to give just a short summary of your background?
Yeah, hi everyone. As Mike said, my name is Jeff Cadwell, and I'm a partner here in the Minneapolis office in the Trademark, Copyright, Advertising, and Brand Management group. And before going to law school, I actually trained as a musician and earned a master's degree in music composition. So when I decided to shift gears and go to law school, I knew the area I wanted to practice in was the trademark and copyright field so that I could kind of retain that creative aspect to my life. And while I do a lot of different things in this space, one of the parts of my practice I like most is working with companies and individuals on protecting their brands and ideas. And so the branding part is really what we're going to focus on today. So I look forward to talking with you, Mike, through this presentation.
So I have to ask, because I'm sure people are wondering, what was your instrument?
I was actually trained as a composer, but my instrument is piano. I can hack a little bit.
Well, we'll save that for just the top of the hour then. So fantastic. And you know, one of the things, Jeff, that you and I have worked on before with clients, which is great, and it's really been a value to them, is to kind of help design their brand strategy. And I recall, you know, one in particular had an international brand, and we were able to go and really look at what were the things that they wanted to protect, what were the investments that they needed to have, and in what jurisdictions. And then, frankly, what brands did they not really invest in, didn't really care as much about, and it's not worth the cost associated with doing that. So you've been a real value to myself and the clients that I work with through Dorsey, and thank you for them. And can you tell us a little bit about, you know, what is a brand and why, you know, how does it get protected, I guess?
Sure. So a brand, which we also call a trademark in this field, is basically a designator of source of a particular set of products or services. And one of the underlying foundations of trademark law is consumer protection, so that if you see a particular brand, you know who the source is and you know the certain quality to expect. So if you picked up a bottle of Pepsi, you would know that it's going to taste a certain way and it comes and it's authorized by PepsiCo. And if it's not, then that's where we have issues with trademark protection. And those brands can take many forms. There can be just word marks or brand names, as we call them. We've got the example of just Cargill up here, but think of any company that you know their name can be a brand name. There can also be slogans that you associate with products or services. We've got the Campbell's Soup slogan up there. Logos or designs can be trademarks, so anything that you associate with the company. And here we've listed the Leaping Caribou for Caribou Coffee, which may not be familiar to all of you across the country, but that's a brand that's local out of Minnesota here. And then there's some more unique types of protection, such as trade dress for the way a product looks or the way its packaging looks. You can even go so far as to protect things like colors or sounds or smells. And then finally, any combination of those elements can be protected as a mark. And so there we've got like the Mosaic mark with their logo, and that can be protected in a unitary fashion.
So I promise I will not ask you to do the Pillsbury Doughboy giggle, but I appreciate knowing that it's protected. So a couple questions I had. Who inside a company should be worried about the brand protection? Are there particular titles of people or folks that should be concerned about it?
I think it should be everybody from the top down that's concerned. I mean, a brand is like your reputation as a company, right? And so if your brand is tarnished in some way or infringed in some way, that's a real problem. The people that I often work most directly with in a company, if they're of a certain size, are the people in the marketing group and potentially the legal counsel that's responsible for working with that marketing group. But really, brand protection is kind of everybody's responsibility, and if you have good employees, they're looking out for things that don't look quite right, and they're reporting them up the chain to the right person.
So if I work at a company and I'm designing a new product or something along those lines, how do I think about the brand, and who would I contact within the company to make sure we're watching it?
It would be the person in the company that's responsible for authorizing the use of that brand. And so if that has to go through legal counsel first to get vetted, which we'll talk about in a little bit in terms of clearing a mark, then that's the route you should go. If you don't have legal counsel, then it should lie with probably the marketing department or the person that's kind of responsible for PR or the public face of the company. But certainly employees should not just be running out and using trademarks and brands on their own without going through the proper channels.
So I noticed that some of the examples that you gave, I have what I would kind of think of as, you say combinations, but it could include, for example, in the Mosaic, not just the logo itself, but also the colors that are used in the logo or the scheme associated with it. So if somebody's trying to protect a brand that's got multiple attributes, does that involve a single trademark process, or are there multiples?
It really depends on your goals and also your budget. You know, with that Mosaic example, there's probably maybe about 4 ways we could go if we're getting to the point of filing trademark applications, right? We could file for Mosaic as simply a word mark. That's one element there. Then you've got the design element that's below Mosaic. You could register that both in color and without a claim of color. And then you could register the whole thing as a sort of unitary mark, either in color or without color. I often tell people to register without color. We can, again, talk about registration in a little bit, but registering without claiming any color gets you broad rights to any particular color scheme. But if colors are important to your company, like the John Deere yellow and green that you see up there, then registering in color can have some benefit in terms of enforcing your rights and saying to the public that, hey, we really do claim those colors as important to our company.
So you kind of described a little bit the kind of overlay of the different types of applications. Can you talk about geographic overlays as well?
Right. So it's important to think about the fact that trademark rights are geographic. So obtaining rights here in the United States is not going to get you much, if anything, in Canada or Mexico or anywhere else. Each country has its own system of protection. And so when you're thinking about adopting brands, you definitely need to think about the geographies involved and where you're going to be rolling out particular products or services. And that can impact a filing strategy if you decide to file trademark applications. And then here in the U.S., specifically, we have kind of a three-tiered system, if you will, to trademark protection. And that's the three tiers really are what we call common law rights, which are developed just by using a mark in commerce without filing an application. So if you start selling something under a particular brand, you would get what we call common law protection. If you're selling only locally, you can file for a state trademark registration, and that would be appropriate for someone who might be, say, in the middle of Kansas and opens up a shop and sells a product out of their garage or something, and it's only to local customers. You would get a state trademark registration. If you're doing something that touches on the stream of interstate commerce, such as shipping goods across state lines or engaging in services that are rendered across state lines, then you would be able to file for a federal trademark registration, and that gets you certain benefits as well. So really, when you're adopting a brand, you need to be thinking at the outset what the geographic goals are, because that can impact the type of clearance searching you may want to do.
So I had a couple of questions about the geographies. So you said that kind of like there's two state law aspects. One is just if I start using a brand, then there's some common law protection, but it sounds like it's pretty weak. But then I could also do a state-based filing. If I'm in Washington, for example, I could do a Washington state trademark filing if I really only intended to offer services here in the state. Is that right?
Correct.
And then, the interstate commerce, it sounds like, if you're a big company, of course, often that's really, you don't even think about it much because you're already in the stream of interstate commerce. But for smaller companies, should they be more worried or more thinking about that as an aspect if they're close to a border? For example, they're right on the border between, states?
Definitely that's something to think about. And if the Supreme Court's definition of the Commerce Clause is pretty broad. So if you can say you're doing anything that touches on the stream of commerce, then you probably would qualify for a federal trademark registration. For goods, you have to be particularly careful and just make sure that you actually have sold or transported the goods across state lines in some way. That's easier to do in a place like the Twin Cities where you have people from Wisconsin potentially, shopping locally. With services, it's a little more relaxed. If you were to open a restaurant in say a college town like Madison, Wisconsin, you could probably claim the benefit of interstate commerce because you can say that people from all over the country are dining at your restaurant because they're coming to visit their students who come from all over the country and that sort of thing. So, that's a discussion to have with your trademark lawyer, but certainly if you can get to the level of interstate commerce to protect for a federal registration, that would be the way to go and give you a stronger set of protections.
Is it possible to file both the state and the federal trademark application at around the same time?
It is. That may not actually be necessary unless there's some reason to get something on the books really quickly, because a state trademark may issue a lot faster than a federal trademark application. Generally, the federal is going to trump the state because it gives you the nationwide protection. So again, that's part of the strategy you would discuss with a trademark lawyer to determine whether that's something to spend the money on or just to pursue the federal registration. I would say most of my clients just do federal registrations.
And is there a cost difference?
Quite significant. For example, the filing fee in Minnesota for a one-class filing is $50, whereas at the federal level for a one-class filing, the filing fee is $275. And then there's obviously attorney time involved as well.
And then finally, I know that there's in IP issues questions of timing. So in some cases, you don't really have to care because the first person who starts using or designing something is the one who has the rights, and in other times you have to file first. Which is the case for trademarks?
So that's a very good question because it really does depend on the jurisdiction. What you're asking about is what we call priority rights. And in the U.S. and other countries that are common law based, such as the UK, Canada, Australia, places like that, we do recognize rights based on use, those common law rights that we talked about, and that's one way to establish priority in a mark. Another way, which we can talk about when we talk about registration, is to file what we call an intent to use federal application, which you can start to stake out nationwide rights before you've used a mark at the federal level here in the U.S. In some countries, however, civil law countries and non-common law countries, there is no real recognition of priority based on use. These are what we call first-to-file countries, and there, whoever files and registers first is going to be deemed the priority owner for the most part. And so really companies that may have a presence in China or Mexico, those are classic first-to-file countries, you should file early and often in those countries so that you don't have an interloper or a manufacturer who decides to run to the trademark office and file before you, because the cost of getting that registration canceled, if you can, is going to be a lot higher than just having registered it in the first place.
And is there any kind of international treaty that helps out?
There is. There's two treaties that we think about with international filing strategy. There's what we call the Paris Convention, which allows you, once you've filed a federal U.S. application, to file in a number of international countries within 6 months of the U.S. filing, and the filing date in those countries would date back to your U.S. filing. So that cuts off some interloper jumping in line. And then there's also an international treaty called the Madrid Protocol that we can use when the circumstances are right to file an application and designate a number of countries around the world by filing an application through the U.S. Patent and Trademark Office based on one of our U.S. marks. And doing that can save you some money because you don't have to hire foreign counsel in those countries to file the applications. But there are some benefits and disadvantages that you definitely want to talk about with a trademark attorney before pursuing that sort of filing.
So let's talk a little bit about what it is that we're actually protecting and how, from the starting point, to go about designing the trademark you'd like to invest in. Can you talk about that?
Yeah, so on our slide here, we've got the spectrum of distinctiveness of trademarks, and really one of the things that you want to think about when adopting a trademark is how strong is it going to be? In other words, how likely will you be to keep others out of similar marks, and how much brand equity can you build in a particular mark? And so in a case several years ago, the court laid out some distinctions of marks, and what we have listed here are the fanciful marks all the way down to generic, fanciful being the most strong type of mark and generic being the weakest type of mark. And in fact, generic isn't really a mark at all. And so let's walk through these really briefly. So fanciful marks are marks that are...
Before you do that, Jeff, just a quick question. So these are kind of in order of distinctiveness. Is that what you're saying?
Correct. Yep.
Got it.
And in fact, in terms of distinctiveness, we have two types of distinctiveness we think about in the trademark world. We have marks that are inherently distinctive, which means that you can sort of build some brand goodwill right away. And then we have marks that require acquired distinctiveness to build up some rights. And that means you have to use it over a period of time so that customers can associate it with you. And the top three marks that we'll go through, fanciful, arbitrary, and suggestive, are the inherently distinctive marks. Descriptive is one where you're going to need some acquired distinctiveness or secondary meaning. And generic is a mark, it's one where we really couldn't acquire rights because it's a generic term.
Got it. So we kind of strike that one off our list and then put a question mark by the second one here, or second from the bottom rather, because it sounds like that's not likely to get us what we want unless we make a really major investment, right?
Right. If you're willing to build up some goodwill or do something where customers will associate that descriptive wording with you, then it might be worth the investment. But those marks are a lot harder to protect and enforce than the top three types of marks.
So I know you had some recommendations on selecting a mark, and I loved in particular the foreign translations as somebody who speaks a couple of other languages. So can you describe what your recommendations are?
Yeah, so we've got sort of three recommendations here, and the first recommendation is to think about, again, marks that are going to be strong and protectable. And so you're in the fanciful, arbitrary, or suggestive, area. And let me go back and unpack those real quick just so we know what those terms are. Fanciful is a mark that you make up. So the example we had on the previous slide was Xerox. It's a made-up word. Nobody's used it before, and so you can develop that mark as your own. An arbitrary mark is where you take a word that exists in the English language, but you apply it to something different. And so there's Apple for computer products, or if you're of a certain age, Apple for record label. You know, the Beatles, they were originally on Apple Records. So, you know, that's an example of an arbitrary mark. And then suggestive marks are ones that they're just a little bit above descriptive. It takes a little bit of imagination to figure out what the mark is. And so a snow rake for a particular type of tool to wipe snow off your windshield, you know, you sort of know what that is, but you don't know right away. And so you could build some equity in a mark like that. And so when you're developing a mark, you want to be thinking about how strong it can be. Obviously, marketing folks like to pick the more suggestive marks because they're easier to sell to the public because the public's going to understand what they are right away.
Kind of pre-sold in a way.
What's that?
Kind of pre-sold in a way.
Right, but that may not be the best way to pick a mark if you're really going to be in it for the long haul. And so the next, you know, once you've thought about picking a strong mark.
So before we move on to that, somebody who's online asked a really interesting question, and that is, why would Apple not itself be generic?
Apple can be generic if you were trying to sell apples, and that's why it's generic. But when you take that term and apply it to something that's not an apple, that's when it becomes arbitrary. And so like my example of binoculars, you know, if you tried to sell binoculars under the brand binoculars, you're not going to get any rights there because it's generic. But if you were going to start a record label called binoculars, that would make it arbitrary.
Got it. So it's kind of cross-pollinization using the food and agribusiness terms.
Right.
Got it. Okay, terrific. And then foreign translations with no va, you know, don't go. What other? How do you actually watch for that?
Well, so that's part of the initial strategy is thinking about how broadly your brand is going to apply, whether it's going to be a U.S. only brand or whether it's going to be a brand that's worldwide. And if it's going to be a worldwide brand, then you do want to be thinking about if the mark has any particular connotations in key jurisdictions. Another, beyond translations, are transliterations you want to watch out for. So if there's a Chinese character version of the mark, or in Japanese characters, if it means something that you don't really intend it to mean, that can be a problem. So that's where engaging some local counsel, if you don't have someone who speaks the language, to help make sure that you're not picking a mark that is going to resonate negatively with consumers. And then I think just generally as a tag-along to this in the English language, just considering the connotation of the mark in general. If some segment of the population might be offended by the mark or might not really understand it the way you intend it to mean, then that might be a signal to look for a different mark.
I won't name names, but we've had some very high-profile brands that fell into exactly that cultural trap over just the last few months. So it's a good reminder to everybody about really somewhat broadly gathering information about the proposed mark within your own company, team, and people who are national speakers of foreign languages.
Exactly.
And then the last point is avoid marks that are similar to competitors, to those used by competitors. And why is that a factor?
There's kind of a twofold reason for that. One is so that you can develop strong rights on your own. Obviously, you know, companies like to compare themselves to their competitors and do things like that, but you know, developing something that can stand on its own is going to give you stronger trademark rights. And then the flip side of that is if you get too close to a competitor, you may be begging for a cease and desist letter or even a lawsuit if they feel like your mark is too close and has the potential to confuse consumers.
You know, I'm thinking of a client I work with from time to time that's got about a $4 million advertising budget, and it's not just the competitors. You're really making a major investment in the company in hopes that people will buy your product, and so you would want to make sure that that investment has the right return attached to it.
Exactly, and as we'll talk about when we think about clearance searching, you don't want to pick something and then have to change all of your advertising down the road and potentially change product labels and everything else. There's a lot of expense to that, and so if you can do the homework before you launch a product, you can end up saving a lot more than you might spend if you have to correct it later.
So I know that in selecting a mark, you recommend a 3-step strategy. And can you address the first step of that process?
Yeah, again, this kind of goes with the question of developing a strong trademark, right? And the question is, are you looking for something that's really going to set you apart from your competitors and to identify the source of your products or services? If that's the answer, then you're on the right side of the slide there, where you're really developing a brand, because that's something you want to own. But if you're just developing something that you want to be kind of a common phrase, or that's going to be a descriptor for a product that you don't really intend to protect and stop others from using, then you're really on the left side, and it's a product descriptor. And that sort of tends toward probably not spending a lot more time investing in that particular descriptor as you would a brand if you're on the right side of the slide.
And when you say investing in, what do you mean by that?
Spending the money to do the clearance searching, potentially filing the applications, and then obviously going down the road of designing labels or advertising collateral and getting off and running with the brand.
Got it. So if, for example, we were trying to protect the fact that Dorsey has great food and agribusiness lawyers by using a specific phrase, then we would be on the brand side. But if we were just trying to help people understand that lawyers are good people generally, it would be a product descriptor, right?
Right. Or even to the more granular level of saying like food agricultural and beverage practice. That's more of a descriptor. We would have a hard time as a firm stopping some other firm from saying they have a food agricultural and beverage practice.
Got it. So once you have identified, okay, we're probably on the brand side, and that means that it's worth taking some form of investment. What's the first step in the investment that you might take?
I think you should consider doing some clearance searching, and that's where either your in-house trademark counsel may come in if you have that luxury, or your outside trademark counsel will come in. And to determine what the right scope is, you kind of also need to be thinking about how broadly the brand is going to be used. If this is a mark that is going to go on product that's sold worldwide or even just across the U.S., then you probably want to do some robust searching to make sure it's available. If it's just a line name that's going to appear on the website and could easily be changed, then maybe you don't do as a detailed level of searching. And what I mean by that is... Yeah,
what's a search? When you say a clearance search, what is that?
So a clearance search is taking a look at the federal or state trademark registers, as well as potentially looking at common law sources here in the U.S., to determine whether anyone else is using or has applied to or has registered a similar mark for similar goods or services, to identify the risk associated with adopting the particular mark in which you're interested. If it's going to be a major brand that you're going to roll out, then you would want to do some comprehensive searching. And when I get asked to do that, I usually use our outside vendor to prepare a search report for me, and what they look at is the federal trademark register. They do a very deep dive there. The state trademark registers, they look at common law sources such as trade name directories, trade journals, websites, all manner of places where a mark might be used on an unregistered basis, and then just generally the domain name registries to see what domain names are taken and how they're being used. And based on all of that very comprehensive look at a mark, we can generally identify 3 characteristics. We can identify how likely is there to be an infringement claim based on using this mark, how likely are you to be able to register it federally, and then what would the strength of your mark be once you develop some rights. And we can determine strength based on what we see out there based on the search.
Let me ask a couple of questions before you move on, if you don't mind. So It sounds like there are some vendors or places where other companies aggregate the information that you'd be doing or seeking in a clearance search. Is that right?
Right. Yes, we use a company called Clarivate that is formerly Thomson Reuters, many iterations of company names. But that's who we go to do our searching. But there are other vendors out there as well.
Clarivate sounds like a pretty good brand, but I'm not sure if it's what it means, which I guess makes it a good brand, right?
It's fanciful, maybe,
Yeah.
unless it has some meaning that I don't know.
There you go. And then, roughly speaking, are there tiers of cost associated with running those kinds of searches? So, can you say, okay, I want just the basic, and then, the basic plus, and then Supreme Unleaded or something?
Yeah, absolutely. So the basic search, which I didn't mention yet, is just kind of doing a search of the federal and state trademark registers just to get a quick look at a mark.
And that would be like the USPTO or something?
Right, the USPTO and the state trademark registers. And then maybe a little bit of Google searching, but not much. In Dorsey speak, that's going to be probably about 500 to 1,000 to look at that sort of search. And then moving up to that comprehensive search I described, you're probably close to the 3,000 range, including the search cost itself and the attorney fees to look at it and prepare a report. So there's a higher level of investment for that comprehensive search. And then the other thing to think about is if this is a truly global brand that you're going to roll out, whether you want to do some searching at just the federal or the country trademark registers where you're interested in adopting the mark, or whether you want to hire foreign counsel in key countries to make sure that it's clear. And so that can, again, add maybe 1,000 or 2,000 or more for each country that you're looking at. So it can all add up depending on how important this brand is. But as I mentioned, doing the homework ahead of time can often be a lot cheaper than having to deal with it at the back end if you get a cease and desist letter and have to change your branding.
Now, at what stage of the product development process would you start thinking, we might want to either start with the basic and then decide whether we want to get a comprehensive search or go straight to a comprehensive search?
It really depends on the company and the appetite. Some clients just skip straight to a comprehensive search because they know it's an important mark. Some companies will give us a list of marks. They'll say, these are our alternatives, and this is the order in which we prefer the marks. Can you kind of go through and knock them out and see what's available? And then we'll go back and do a comprehensive search on the ones that aren't knocked out. And then some companies are just risk, they're willing to tolerate some risk, and they'll just have us do that basic search, and they'll launch away and hope nothing happens. So it really depends on your risk tolerance and kind of your view of the mark. But as I said, if it's going to be a really important brand, that's where I would invest the money at the front end.
So I kind of think of it, from a client perspective, if I've got something that we believe is going to be a marquee or key product that the company will be basing substantial investment on, then it makes sense to clear the trade names and marks early on in your market process. So the product might already be designed and being developed, and we just haven't decided what name to put on the end of the side of the product. But but fairly early on, I would want to decide that, it seems.
Exactly, because especially if you have some moving parts like some international jurisdictions to check. If you're a company that does a lot of business in South America, then we will need some lead time to coordinate with South American Counsel to check the availability.
And so you said that the process results in a report, basically, that identifies whether a particular mark is likely enforceable both on the federal registration, which means that the U.S. Patent and Trademark Office will, in fact, issue a trademark on it, and then also some protection on the back end if somebody tries to copy, right?
Right.
And how does that process work when you're working with a client on these types of topics?
Well, typically that information is born out of what the search results reveal. So, if the search results didn't reveal too many similar marks in the similar space, then you may have a strong mark in terms of protection, and you may have a fairly easy chance of registering the mark. Sometimes we find that you don't have much infringement risk, but you may have trouble registering a mark because there's what we call clutter on the Federal Register, and some companies may have really broad registrations that they're not actually doing what you intend to do with your mark, but their registration might block you. And so the benefit of the search is kind of understanding how all of those things work hand in hand. And one thing I wanted to say specific to the food and beverage space is that this type of searching is very important because you might not think of things as being related that the trademark office or the courts think of as related. And by that I mean, there have been cases that say that food and beverage products are related to restaurant services, such that if you roll out a food or beverage product and there's a restaurant with a similar name, that could be considered trademark infringement. And even more specific in the alcoholic beverage space, there's a pretty broad view of what goods are related. So you will find beer marks being refused based on wine marks and vice versa, even though, most people probably don't think that the source of a beer with one name is the same as the source of a wine with the same name. So, these are things that Trademark Counsel can kind of help guide you through in this specific area of food, beverage practice.
Now, once you decide to do the clearance searching, you have 3 boxes: brand defensively, brand offensively, and unsure. Can you describe what you mean by those?
Sure. So branding defensively is where you would kind of take the approach that this is a really important mark and we're going to go ahead with it. And we're going to get to federal registration in a second, but there in the U.S. you would want to file intent to use trademark applications to plant your flag right when you're interested in a mark so that you gain that priority against all others. And that helps you then get the priority window to file within 6 months in the foreign countries where you're interested in using a mark. So that's kind of taking the most proactive approach. Branding offensively is maybe you've started using a mark, but it's become really important to you. Then you want to pursue registration and enact a strategy to kind of lock down rights so that your competitors don't come along. And then if you're unsure whether you have a brand or a product descriptor, you may just decide to wait it out and see. You roll out the product and see if it really resonates with customers, and if it does, then maybe you take the branding approach and really try to develop the brand in it. If you roll out the product and you think, well, this is kind of weak, we're not going to gain much traction with it, maybe you don't invest the money in the mark.
So I hear test marketing from time to time. Is that what you're talking about?
Yeah, and it really, again, depends on the size of the company and the appetite for the brand. If a test market is going to be for a product that you really do intend to be a big brand, then you want to go for it defensively. If it's a test market to see if it's a brand that may or may not take off, it just depends whether your budget is going to allow that sort of proactive approach.
Got it. So what's the next step?
So the next step is to determine, again, this is where we were going, what sort of brand protection you want to pursue. If it's going to be a really important brand for a company, then you want to consider trademark registration strategy at that point and file trademark applications. If it's one where you aren't sure, you could decide to wait. This is an important distinction between trademarks and patents. Patents, there is a certain time at which you must file a patent application or you can no longer claim the rights to your invention. Trademarks, because we recognize common law rights here in the U.S., you could choose to establish some common law rights to see if a brand takes off before you invest the money in filing an application. And then, thinking about all those things together, you also need to consider the geographic scope, because if it's a mark that's going to be used in a first-to-file country, then that may push you toward the more offensive strategy of filing early and trying to stake out protection.
Now, if we're not looking at a state-only protection, what are the benefits of a federal trademark?
So here in the U.S., you do get some great benefits by federally registering your mark. First on the list is your ability to use that circle R symbol that you often see, and that is only reserved for federally registered marks. So if you don't have that, you can't use the circle R. It also gives you the ability to provide notice to third parties, both in the form of using that circle R symbol, as well as the fact that your mark is going to appear in the records of the Patent and Trademark Office, so that if somebody else is doing one of those clearance searches, your mark will come up a lot higher on the list than if you're just a common law user. If you get a federal trademark registration, you're entitled to claim nationwide protection. And so that can be beneficial to a company that may be, say, local here to Minnesota, Iowa, and Wisconsin that plans on expanding at some point. And if you expand into a territory and somebody has adopted a mark subsequent to your federal registration, you can oust them based on your nationwide protection. So that's a good benefit to have.
So put a different way, you become the chatter that someone else worries about, right?
Right. Yeah. Again, it's notice and it's there, and hopefully if somebody else is looking to adopt a mark, even if it's a local mark, they're going to stay away from your mark because they see you and you have that registration.
Terrific. So it's like a chilling effect then.
Right. And there can be advantages in litigation, especially for the marks that are inherently distinctive that we talked about, the fanciful, arbitrary, and suggestive marks. Though if you have that federal registration, it's going to be presumed valid by a court as part of a litigation action. As we described before, if you have a federal trademark application here in the U.S., you can make priority filings in foreign countries and have those countries treat the filing date as your U.S. filing date if you file within 6 months. Another important benefit, especially for companies in the consumer product space, is the ability to register your trademark registrations with U.S. Customs and Border Patrol and to keep potential counterfeit goods out of the United States. And this sort of customs regime, we're talking about U.S. federal registration right now, but this customs regime exists in other countries as well. So if you had, say, a Chinese registration, you can record that with Chinese customs, and they will, in theory, keep things from going out of China that fit the registration. So that's a very valuable thing for a consumer products company to have. And then finally, there's an increased value to your business just as in terms of perception. If you're engaging in M&A activity and you're potentially the acquired, having federal registrations allows maybe the company to be valued a little more because the acquirer knows that the brand is clear to use and they could roll out the brand in a stronger way. Also, if you're going to the bank to get some financing, you have some collateral there in the form of a federal trademark registration against which they can file a security interest. So there's some benefit to the company there. And then one other one I wanted to mention that's not on my list here is registration of domain names. With all these new domain names that are on the market these days, .bank, .clothing, you name it, some of the registries, if you have a federal trademark registration, will let you register for your brand early before the general availability period. So that can be a benefit to having a federal registration as well if you have your heart set on one of the fancy new domain names.
So some questions about the trademark process, just as a general proposition. First is, it's always hard to kind of estimate how much things cost, but because it depends on the nature of the rights that are being sought and the complexity of the filing. But do you have a kind of ballpark about how much these things would cost if we decide we're going to go for a federal registration?
Yeah, so one thing to keep in mind is that in the U.S. we file by a class system, and that's actually most countries do. And by that I mean the goods or services you want to protect have to be classified in a particular class. There's 45 different classes of goods and services. And so, like printed goods are in 16, clothing is in 25, retail services are in 35. So there's these different classes. So the first thing we have to do is figure out how many classes are involved. Each class, as I mentioned before, carries a $275 federal filing fee. If just to make it easy for a one-class filing, usually you'd probably be looking at about $1,000 to get the application on file, including our time and the filing fee. And that excludes any of the previous clearance searching. That would carry its own cost, of course. Let's say that it sails along and there's maybe one minor ding from the trademark office, but no major issues are raised and no third-party challenge comes up. You could easily get in and out of the trademark office for a couple, $2,000 to $3,000 for that registration. Where the cost really gets expensive is if you want to pursue one of those unique marks we talked about, like maybe a color mark or a sound mark, something like that, where there's a little more work involved, or where there's a refusal from the trademark office where we have to argue with the examiner. That's where the cost can really mount, and you could easily get into the 5 figures to obtain a trademark registration, assuming you can persuade the examiner to grant it.
So you've got kind of the initial filing process, and that's the beginning, of course, and then they can ask questions or others can potentially come in and try and interfere with your mark, is what you're saying.
Exactly. There's a couple ways things can come up. First, the federal trademark examiner can raise a challenge for either saying the mark is descriptive or requiring different wording for your description of goods or services, or even citing a third party's mark as too close to yours. That can happen, or if the examiner approves it for what we call publication, at that point a third party can lodge an opposition of the application, which is like a mini court proceeding to try to prevent you from registering the mark. And that easily could get into the 6 figures if it's a highly contested proceeding. And so all of that is good reason to do the homework at the outset before you file. And of course, this is the U.S. only. These things can happen all around the world. And so, one thing that we can help you with if you're looking at launching a global brand is kind of figuring out what are the potential costs, help you decide what countries are the most important, what are there tiers of countries to focus efforts on, how does the budget match what you've got to spend.
And I assume that if you get to a point where there's a big contest and you decide, this one's not worth it, can you ditch the filing?
You can always walk away from a trademark application. There may be some consequences to doing so if it's been opposed, but you can generally always abandon. Then the question becomes, do you want to continue to use the mark without registration? Is there still some risk of that party suing you for outright trademark infringement? And so that's a consideration as well.
What's the total amount of time from filing to getting some response in the normal course, so without a bunch of contests?
You mean filing to registration?
Correct.
So if you filed a use-based application as opposed to the intent to use, which means you file and you claim that you're using the mark as of the filing date, and there's no issues that really come up, you could potentially get a trademark registration in about 8 to 12 months. I've seen some even come a little quicker, but that's about the relative time frame. If you file the intent to use application, you can actually, you have to prove use at some point to get the registration issued, and you can get extensions of that deadline. And so the lifespan of an intent to use application can sometimes be up to about 5 years before you get a registration. And that's dependent mainly on when you're ready to prove use of the mark.
So expectation setting, it's not like you file and then get an instant response.
Right. It does take time, and in fact, after you file initially, the first examination doesn't happen for about 3 to 4 months. So you file and then you just kind of sit and wait till the trademark office takes a look at it.
Now, final question on this slide is, how much time does it take internal to a company? How much manpower does it require to get you the type of information that you need and that kind of thing?
It really depends on how many marks we're filing and what sort of thing we're doing. I would say the most intensive bit of information sometimes happens with the intent to use applications, because often we will file for a broad set of goods and services at the outset because the company is not quite entirely sure about the exact product line. And by the time we come around to having to prove use, we have to specify the particular goods and services that are in use. We have to supply evidence of use, and we have to supply the dates the mark was first used. So that's a matter of working with somebody to gather that information. That information may be necessary if we're going to file based on use right at the outset. So typically, I work with usually one point of contact in a company, whether that's somebody in the marketing group, whether that's a paralegal or a trademark counsel. But usually it's one person, and then it's up to that person to determine how widely they want to delegate the responsibility of all the information we're going to need.
And it sounds like in the food and beverage space, it might be even a little bit more complicated because of those unique requirements that you described earlier. Is that true? So for example, if I developed a terrific kind of beer, I'd need to figure out, is there a wine that's got a similar name and a restaurant and the like? Is that the case?
Yeah, but we, as outside trademark counsel, we would look for those sorts of things in our searching. So we would be able to identify that at the outset. You do have, extra steps you have to follow in the food and beverage space in terms of labeling approvals and things like that. So obviously, you'll want to factor how long that sort of thing is going to take in with your trademark clearance as well to kind of set the overall timeline. Because, for example, for alcoholic beverage approval, you need the brand before you can go through that process. So you want to make sure you set the right timeline.
And give yourself a good cushion, given that we're talking 8 to 12 months before you get clearance in the best case.
Exactly.
So then once you get the mark, can you describe how you can use it?
Sure. So once you begin using a mark and it hasn't registered yet, the best thing to do is put the TM symbol beside it, or you could use SM if it's a service mark. TM is just more generally recognized for a trademark or a service mark. And by that, I mean service mark, I mean basically you're using it to designate services. That will signal to third parties that you're claiming trademark rights, but they're not registered yet. Once it does become registered, you can use the circle R symbol beside it. And there are benefits to using the circle R symbol in that it can help with getting damages in a trademark litigation action. The other thing you want to do is make sure that you're using the trademark properly to really develop goodwill and brand recognition. And so I use the Rollerblade example here as a good one. The key is to use a mark as an adjective and never as a noun, because if you use it as a noun, it runs becoming generic. And so Rollerblade inline skates would be the way to designate that as a brand, not we sell rollerblades, which makes the trademark a noun and kind of runs the risk of that term just becoming a generic term for inline skates. And then you generally also want to avoid making your marks into verbs because that can kind of confuse your consumers and also weaken your trademark rights. So, don't say get out and go rollerblading, get out and go skating using rollerblade inline skates or something like that. It sometimes takes some creativity on the marketing side, but the more you can do that, the more you can really make that mark stand out and defend yourself if you're ever challenged for something becoming generic. And the last thing...
I'm just going to make a kind of contrast there, because as the business person, I'd love if my Kleenex, for example, became such a ubiquitous concept that it was in fact the category.
But you run the risk of somebody challenging you. And we recently saw a case about the Google mark, whether that has become generic for internet searching. And so you do run the risk of people challenging your rights that they've become generic. And the one tag-along I wanted to say here is that slogans are kind of a thing in and of themselves. It's kind of hard to fit a slogan into this sort of rubric. For slogans, your best bet is to use the slogan independent or under the mark or in some way that makes it stand apart, just so that you can kind of claim protection of that slogan. Once you start embedding a slogan in a sentence or something like that, then you also run the risk of weakening a slogan.
So could you use, let's say, rollerblade inline skates with the logo attached to it, and then under that use the same word as a verb, rollerblading for life or something?
If you were going to try to stake out some protection in the slogan rollerblading for life, you might be able to get away with that. I would probably counsel against that unless there's a really good reason to do it, unless you think you're going to really build up some good recognition in that phrase.
Got it. So once you get the mark and you've identified it properly using the either TMSM or the registration symbol, can you describe the litigation process, either where you might be defendant or plaintiff?
Yeah, and we've talked a little bit about this next slide, the infringement slide, in terms of the clearance searching and the application process. But certainly, when doing your homework, you don't want to adopt things that are similar to your competitors' marks. You want to avoid similar product designs, packaging designs, You maybe even want to avoid similar color schemes to another competitor if they really have staked out some rights in a color. Doing all that will help you avoid getting a claim lobbed at you. And if you do get some sort of claim lobbed at you, there's several ways that can come. You could get refused by the trademark office, which means you can't register the mark. You could get opposed, which we described before as kind of like a mini litigation to prevent you from registering the mark. You could outright get sued in federal court or state court if you're only using at the state level for trademark infringement. And in a lawsuit, the damages potentially range from getting an injunction from you not using the mark to actual damages and potentially attorney's fees and required corrective advertising. So there could be some significant expenses there. One thing I'll say about the contrast of an opposition at the Trademark Office is that the Trademark Trial and Appeal Board, which hears those disputes, doesn't have the ability to award damages or attorney's fees. So the only remedy there if someone opposes your mark is preventing it from registering. They can't get any cost fees or damages out of that action.
But we're still paying for, Dorsey lawyer time and your own internal management time and the like, right?
Exactly.
So what my takeaway here was that it really is worth a reasonable investment on the front end, as you say here, clear marks before adopting, to make sure that you don't put yourself in the crosshairs of one of your competitors.
Right.
And then once you get the mark and invest in your brand, you're making a significant investment. You want to make sure you have a return on that. How do you protect yourself from others coming in to try and take that over?
Yeah, you really do want to police the mark. It's incumbent on a trademark owner to kind of maintain their trademark rights. Nobody else is going to do it for you. So there's several ways you can do that. Most of our clients subscribe to what we call watch services, and those are reports that our vendor provides to us on trademark applications that are similar to the mark we're watching, also to domain name registrations, and then common law or business name registrations that are filed. So we can see those come through and then decide whether to take action. A good place at the ground level is for your employees who are going to trade shows or looking at trade journals. If they see something that's similar, to make sure that they know to report those things. You may hear things from customers. You may get complaints about a customer who's confused, and then you look into it and you find a competitor has used a similar mark. Another way is to do some internet searching to monitor social media. I have one client who's particularly social media savvy, and they have a person whose job it is just to kind of review social media, not only to post things for the company, but also to look for infringements that occur on social media. That's a full-time job these days. So keeping a watch on the internet. And then, just generally keeping your eyes open and having your employees keep their eyes open. If something comes to your attention that seems like somebody's using something too similar to yours, then it's time to take action.
What's the rough range of costs for a watch service?
It depends on what you're watching. I would say, you'd want to budget maybe about $700 a year per mark. It would round out. There's design marks cost a little more to watch than word marks, and then the kind of domain services cost. There's different pricing tiers, but on average about $700 per watch per mark that you would subscribe to would be a good range, and that's an annual fee. And then, we generally don't charge much to review those. Certainly where the cost arises is where we find something that's worth reporting to the client and where action is required.
So one of the things that, just kind of a shout out to you and your practice, it's helped myself and the clients I work with a lot, and that is the Customs and Border Protection. If you've got a product, in particular anything that's going to be sold to a consumer, and you're investing in that mark, if there's a knockoff, you can not only get it seized, but in some cases have people be arrested for the infringement and the like, and it can really help protect your overall brand. So thank you again for your help in those areas.
Yeah, and I would, again, echo registering with Customs. It's not that expensive, especially here in the U.S. And I would say that for my clients where I've got those marks recorded, I maybe get a call every couple months from customs to say, hey, we've seized this, can I send you some pictures so your client can tell us whether it's legitimate or not? And so, it has proved its worth.
Terrific. Well, proving our worth by closing out on time. Thank you, Jeff. This has really been terrific. Do you have any final word for the participants?
I think, again, do your homework early, because if you invest the money in clearing and making sure the brand is available, it's going to be a lot less costly than having to deal with infringement issues on the back end.
Terrific. Well, on that note, thank you, Jeff, and thank you to each of our participants. For those who would like CLE credit, then you will receive a reminder email which was sent yesterday with Michelle Hubble's information. Just respond to that sign-in sheet, and she'll respond by sending you CLE information for the jurisdictions in which you report for continuing legal education. We really appreciate your help and your participation. Please tell your friends about this program and series, and please give us feedback on the program and our way of presenting it. We really appreciate your feedback, and we do weave that into future presentations. And just a quick shout out to my partner and friend, Jeff Cadwell. If you're looking for an exceptional lawyer in protecting your brands, I do highly recommend that you contact Jeff. So thank you again, Jeff, on behalf of the clients I work with, on behalf of the firm and the food and agribusiness clients and friends who logged in today for this great program.
Thank you.
All right, and with that, we will end the program, and thank you again to everyone who participated.